Imagine you checked US citizen by mistake on a work form, or maybe someone told you that saying you were a citizen will help you get a job, a benefit, or legal status. What if that one false claim could cost you your chance at residency permanently? Welcome back to Immigration Unpacked, where we dig into the latest in US immigration policy so you know what's changing and how it might affect you. Today we are breaking down the USCIS updated rules around false claim to US citizenship, what they are, what lead to the change, what the risks are, and how to avoid mistakes. On August 20, 2025, USCIS issued Policy Alert PA 2025-17 updating its policy manual regarding false claim to US citizenship. These changes clarify how USCIS determines inadmissibility under the NIA subsection 212A6C2, the law that deals with false claims of citizenship. Here are the key takeaways. The first is no intent requirement for certain claims. Under the decision in matters of Zhang 2019, the Board of Immigration Appeal held that a false claim to US citizenship does not require proof that the person knew the claim was false or intended to deceive in order to be subject to immigration consequences. 2. Effective date and scope. The law applies to false claims made on or after September 30, 1996. It applies when someone falsely claims citizenship for any purpose or benefit under federal or state law, including immigration benefits or even benefits offered by states or employment situation. The third is materiality and subjective intent for benefits. While intent to lie knowingly is not required in all cases, officers now have to determine whether there was subjective intent to achieve a purpose or benefit under immigration or state federation law, and whether the false claim was material, meaning the citizenship status matters for what was being requested. The fourth is permanent bar for many immigrants. If someone is found admissible under this rule, they often face a permanent bar to adjustment of status, meaning they cannot become a lawful permanent resident. Waivers are not generally available except in narrow circumstances. For example, certain people who resided in the US before age 16. Let's look at the legal foundation. How did we get here? To fully understand these shifts, we need to unpack the legal background. INA section 212A6C2, the relevant section of the Immigration and Nationality Act. It says that an alien, that is non-citizen, who falsely claims to be a US citizen for any purpose under federal or state law is inadmissible. This was established by the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. Matters of Zhang 2019, a decision by the BIA, the appeal body for immigration cases, that clarifies that the false claim ground does not require proof of knowledge or belief that the claim was false. That is, the person need not have known it was false. That change is now embedded in USCIS policy. Historical distinction between false claim versus fraud, willful misrepresentation. Prior to September 30, 1996, false claims were often handled under the broader fraud or misrepresentation ground. After that date, false claims have their own ground under NIA section 212. The difference matters because the availability of the waiver differs. So what happens if USCIS determines someone has made a false claim to citizenship under the updated policy? Here are some of the major consequences. Inadmissibility. The person can be denied certain immigration benefits, visas, green cards, naturalization. Being inadmissible means USCIS or immigration adjudicators say you are not eligible because of this issue. permanent bar from adjusting status. For many applicants, if their false claim is post 1996, they cannot adjust status. Example from non-citizen to permanent resident. There are few exceptions. No waiver in most cases, unlike some other grounds. Example is some type of fraud or misrepresentation. False claim of citizenship generally do not permit waivers unless the person meets specific narrow exceptions. Criminal penalties in some cases. In addition to immigration consequences, there are criminal statutes that make false claims punishable. For example, 18 USC section 911 makes it a crime to falsely and willfully represent oneself to be a US citizen. Conviction can carry imprisonment up to 3 years, fines, or both other state federal consequences. If you claim citizenship to obtain a state benefit, to work, and so on, those situations can trigger administrative or other legal actions. It is not just about USCIS, other agencies or employer might act. Not everyone is in the same boat. Some people are more exposed, others may qualify for relief. Let's compare. Who is most at risk? Anyone who made false citizenship claim after September 30th, 1996, especially relevant for those applying for adjustment of status, permanent residency, naturalization. Those who falsely claim to be citizens in form like Form I-9 or to private employers or for state or federal benefit, even if not directly to a USCIS officer. The policy clarifies that claims do not have to be made to government officials. Exceptions or narrow relief. There is a narrow exception for certain individuals who permanently resided in the US before age 16. In those cases, waivers or exceptions might apply. False claims made before September 30th, 1996 are not covered under the false claim ground but may still be evaluated under fraud or willful misrepresentation grounds, which sometimes allow waivers. Materiality matters. The false claim must have been material, that is, citizenship must have been relevant to the benefit or purpose sought. If someone falsely claims citizenship but that fact did not affect the decision because citizenship didn't matter, the ground may not apply. So why the crackdown? Policy goals and motivation. What's driving USCIS to tighten the rules now? Several factors: policy, legal, political, and practical. Integrity and fraud prevention. USCIS says that they want to restore more robust screening vetting processes to detect fraud or misrepresentation in applications. False claim to citizenship undermine the integrity of the immigration system and policy trust. Court decisions. Matters of Zhang force clarity about when intent is required without clear updated policy guidance. USCIS risk inconsistent application. The August 2025 update ensures officers have consistent criteria. Legal and legislative mandates. Congress provided for the NIA Section 212A6C to ground in 1996. USCIS is implementing what law requires. The administrative update reflects statutory obligations. Deterrence. With stricter rules and fewer chances for waiver, the agency is sending a strong message. False claim, even inadvertent ones, can carry serious long-term consequences. Here are some hypothetical and real-time examples to help you understand how this policy plays out. Hypothetical A. The job applicant. Maria is not a US citizen. Her employer asks if she is a US citizen. She checks yes, mistakenly, thinking citizen and resident were similar. Later, when applying for permanent residency, USCIS discovered the form under the new policy. Even though she didn't intend to deceive knowingly, she might be found inadmissible if that claim was material to her employment or any benefit, and if it's after 1996, she likely cannot adjust status. Hypothetical B. Benefit seeker. Jamal applied for a state program that explicitly requires citizenship. He fills out paperwork saying he is a citizen, believing that it just means legal residence. USCIS or state agency verifies documents later. Because he claims citizenship to get a benefit, his false claim is for a purpose or benefit. Under state law, materiality, if citizenship was required, his claim was material. Consequences kicking. Example from case law USCIS practice. While USCIS has not published a public case yet under the new policy, as of the policy alert, earlier cases under matter of Zhang have shown that knowledge or belief of falsity is not required. Also, cases involving employment verification I-9 form where citizenship boxes were improperly checked have been ground for inadmissibility. So let's look at risk of mistakes and how to protect yourself. Because the stakes are high, here are things you must watch out for and how to guard against getting caught up in these rules. Know the definition of citizen versus non-citizen. Understanding what being a US citizen means legally helps. Misunderstanding these terms can lead to unintended false claims. Be truthful on official forms. When completing USCIS Form I-9, state benefit applications, always read the question closely. Do not check citizen unless you are one. Even if someone said just say citizen, get legal advice, especially if you are unsure about your status or an older form is involved. Immigration lawyers or accredited representatives can help. Document your residency history. If you live in the US before age 16, you might qualify for narrow exceptions. Having records, school rent, utility bills and so on can help support your case. Avoid advice from unqualified sources. Beware of fraudulent consultants or anyone telling you to misrepresent status. Those promises often lead to worse trouble. What do these changes mean in the bigger picture, and what should people keep an eye on? Long-term impact on immigrants. Some people who thought past mistakes might be forgiven could now find they are permanently barred. This has serious life implications. Access to resources, ability to work, obtaining citizenship and so on. Case law and court challenges. We may see more legal challenges to how subjective intent is applied or what counts as material. Whether USCIS implementation is fair and consistent could become litigated. Policy enforcement and consistency. How well USCIS trains staff and how consistent adjudicators are across different offices will matter. Inconsistent application could lead to unfair denials. Public awareness. Part of the policy is to increase awareness among applicants so people understand the risk. It's likely USCIS will ramp up outreach, informational materials, international effects. Many affected applicants are immigrants, refugees or non-citizens who may have language or informational barriers. Ensuring to access translation, legal help and clarity is key. To wrap up, since September 30th, 1996, false claims of US citizenship can lead to inadmissibility under NIA Section 212A6C2. Under matters of Zhang, intent or knowledge is not strictly needed in many cases. USCIS updated its policy manually in August 2025 to clarify materiality, subjective benefit or purpose, exemptions and permanent bars. The consequences are serious: permanent bar for many, loss of status, inability to adjust, but there are narrow exceptions and ways to protect yourself. Be truthful, understand terms, get legal help, keep records. If you or someone you know is navigating immigration forms or uncertain about a past claim, don't wait. Reach out to a qualified immigration attorney or accredited legal service. Double check forms, don't assume citizenship unless it is legally true. And if you are applying now, make sure you know the updated policy, because after August 2025, USCIS has made clear false claim can cost you far more than you might think. Thanks for watching Immigration Unpacked. If you found this video helpful, like, subscribe and hit the bell so you don't miss our updates. Leave your question in the comments. What else are you worried about when it comes to immigration law? We want to know. I want to help you clarify. Until next time, stay informed, stay protected. Bye.